So what I want to do today is talk about healthcare decision-making rights and responsibilities. And I will address some of the issues related to the rights-based questions that came up earlier during Isabel's talk. I'm going to talk about laws that apply to healthcare treatment when it happens in home, in hospital, and long-term care. And because these are rules that have not been overridden by the pandemic provincial health orders. However, as we've all lived, the provincial health orders have definitely changed things, and they will require some creativity, I think, from all of us in how to make sure the laws are respected. So what I'm going to talk about today, I'm going to briefly outline the basics of healthcare consent law. I'm going to summarize some of your healthcare decision-making rights as a person who's receiving care. On the other end, I'm going to explain some of the legal duties that people who make decisions for other people about healthcare have, and we call these substitute decision makers. And I'm going to go through some special rules that apply when antipsychotics are given to people in long-term care. So I'll get to some of that question that Isabel had and just expand on some of what she said. My button is just visible there. There we go. So just a few words about myself. My pronouns are she and her. I'm largely of settler heritage, and I'm speaking to you from the unceded territory of the Squamish, Musqueam, Tsleil-Waututh people, of course, as an uninvited guest on their land. I'm a lawyer by training, and my work is more looking at system change, and nothing I do looks anything like what you see lawyers do on television. I've been with the Canadian Centre for Elder Law for 15 years now. So just briefly on the next slide, a few things about the Canadian Centre for Elder Law. We are part of a non-profit agency called the British Columbia Law Institute, which is BC's law reform agency. So the organization responsible for thinking about how to improve laws in British Columbia. The BC Law Institute is a non-profit agency, and we're completely independent of government at the Canadian Centre for Elder Law, although we do sometimes get funding from different branches of government to do different kinds of work. You can see from the slide here that pieces of our work, we do the law reform, we do a lot of consultation with people to find out what's going on, how we can improve laws. We do a lot of research, and we produce educational tools to help people understand their rights and responsibilities under the law. And I'm going to mention a few tools that we developed with the Alzheimer's Society of BC related to healthcare consent toward the end of this presentation. So who provides consent, and how does consent happen? On this slide, I'm highlighting 4 key aspects of the law in relation to healthcare consent, and this is healthcare happening anywhere. So there's no treatment without consent. That's the first piece, unless there is an emergency. And so an emergency means that a doctor, a physician wants to provide care to save someone's life, prevent serious physical or mental harm, or alleviate severe pain. So that's emergency treatment, or someone can't speak for themselves. In those extreme cases, a physician can do something. They just like what we see on Grey's Anatomy, right? Someone's unconscious, we don't deny them care because they're conscious. In emergency, there's some treatment that can happen. But outside of those emergency situations, treatment without consent from the right person under the right circumstances is a battery. In fact, the fact that we have a health emergency right now due to the pandemic is not the same thing as emergency, right? Emergency is specific situation in relation to your own well-being. So the second thing I want to say about healthcare treatment in BC is there a presumption of capacity. And so what that means is healthcare providers, anybody providing care, we assume that people have the ability to make their own decisions regardless of disability or age. And this means that in most instances, a person can make their own healthcare treatment decisions. Now, there are exceptions, right? But if somebody doesn't have a guardian appointed to take care of them and make their own decisions, each time healthcare is needed, the nurse or the physician is checking with that person to see what kind of healthcare they want. If a person does not have capacity to make their own decision, and that means they don't understand the information relevant to the particular health question at issue, they can't understand, they don't understand what is wrong with them, they can't understand the risks, or the benefits of the care. If they don't have capacity, then someone will provide substitute consent for them, because healthcare providers can't provide treatment without consent from someone. So my third point here, substitute consent needs to be from the right person. The healthcare provider has to get the consent from the correct person. So that could be a guardian if the court has appointed a guardian. It could be a representative if you don't have ability to make your own decisions and you've chosen a representative through a representation agreement. And if those two things hasn't happened, the healthcare provider is choosing someone, a next of kin, who's available to make healthcare decisions for you. And when they make this decision, who they choose is based on a descending list of family members that's provided in our healthcare legislation. So they're considering, do you have a spouse that is present to make decisions? If not, do you have adult children? They kind of go down the list. The list includes close friends. So if you don't have immediate family, you could still have a friend to make decisions for you, possibly, when you can't make decisions for yourself. If there's nobody else, the public guardian and trustee is going to figure out who's going to make healthcare decisions for you. Now, finally, healthcare consent decisions must be informed. And what that means in practice is that physicians or nurses or whoever else is involved in the care situation, they need to answer enough questions for you to make an informed decision about whether you want this medication, to undergo this surgery, to go to this facility. They're supporting you to make an informed decision. And so while I'm saying consent over and over and over again, of course, there is a right to decline treatment. So the right to consent is also the right to say no. It's a right to change your mind and withdraw treatment if you decided you didn't want that treatment after all. Now, I want to highlight 4 specific healthcare decision-making rights and responsibilities in addition to this general thing about what healthcare law says. So because I think these rights are not really well understood by folks working in healthcare and just by everyone. So the first one is when we're receiving care, we have a right to accommodation of our communication needs. So these are the communication needs specific to you. And this doesn't mean just can you speak English and do you need an interpreter, but it means that healthcare providers are legally required to communicate with you in a manner appropriate to your skills and abilities. So for example, the first presenters today from the Alzheimer's Society were talking about dementia, and they made a lot of good points about communication with dementia. And so similarly, people who are providing healthcare to someone living with dementia need to consider what are the communication abilities and needs of that person living with dementia. As Mariana said, speak slowly and clearly, right? And make sure the room is quiet so they can hear you. There are a lot of things that healthcare providers can do to facilitate communication with people living with dementia. But generally, on top of that, our human rights law says that people with disabilities have a right to accommodation of their communication needs in any kind of healthcare context. So we know that the Charter of Rights and Freedoms applies to healthcare. We know that human rights law applies to healthcare. And people with disabilities have human rights to accommodation of their unique needs and abilities. And so what this means in practice is that healthcare providers really need to get to know that person they're providing care to and try to understand how to communicate with them in a way that's going to work well for them. Now, moving on to the second slide, and this slide ties in with the exclusion of family members that Isabel was speaking to in her talk. So when we're receiving healthcare, we have a right to supported communication and decision-making. And so what that means is if a healthcare decision needs to be made, maybe you need help from someone in your family to understand the question or to figure out what to do. Healthcare staff need to invite sort of those supportive, non-abusive family members into the conversation about your care needs. This right to have these people involved in the conversation is right there in our healthcare consent legislation. And this law has not been kind of eradicated by provincial health orders. It does mean that family members can't always be there in person at every moment of the day. We need to be creative about how we include family members in conversations about healthcare needs. So third, I want to say something about the responsibilities of people who are making decisions for someone else. So you might be a representative, or you might be a guardian, or you might be just making a healthcare decision for one of your family members because they can't make decisions for themselves right now. Even though they can't make decisions on their own independently for them, and so someone else is making decisions for them, these people still have some rights, and importantly, they have a right to be included in decision making. Now, whether the person who's making decisions for someone else is called a guardian or a representative or a temporary substitute decision maker, there are slightly different responsibilities, but at bare minimum, there is a right to sort of check in with that person you're making decisions for and involve them as much as they can be involved. And depending on their disability, their health issue, they might have different abilities to be involved, right? If they're unconscious, they cannot be involved in healthcare decision making. But if they have, mild dementia, they probably can then be very involved, if not making their own decisions. Once dementia progresses somewhat, they may not be able to make their own decisions, but they might still be able to say, they don't feel good when they're on this kind of medication, or they'd rather receive care in the facility that they're comfortable with rather than going to hospital. So they can still maybe participate in some ways, even if they can't direct their own care. Now, the third thing that I want to highlight is that people who are living in long-term care can still sometimes make some of their or all of their own healthcare treatment decisions. So some people can decide to admit themselves to long-term care as well because they are able to understand the issues involved in that choice. But sometimes the decision to admit to long-term care is made by family members when people's health issue could be dementia, but it could be something else. It's too progressed for them to really understand what's going on and the risk involved in living at home. In that case, there might have been a capacity assessment, and someone else, like a spouse or an adult child, might have made the decision to admit them to long-term care. But that person still might be able to decide about medication. They might be able to say that the antidepressant makes them too sleepy and they don't like it. They can still talk about their experience on medication, or they might even be able to direct all their own health care. The decision about whether a person has what we call capacity to admit themselves to long-term care is a different question from capacity to make decisions about health care. You'll remember a moment ago that I talked about the presumption of capacity. So even when people are in long-term care, we still presume they have capacity to make their own healthcare choices, unless it looks like they can't. So the healthcare provider, the nurse, the physician always have to turn their mind to what is this unique person's ability to participate in healthcare treatment decisions and make an assessment based on what's really going on in their lives. We don't assume that people can't make decisions just because they have a disability. And so finally, I want to talk about antipsychotics because I know that came up earlier, and I think that's an issue we've been thinking about a lot in terms of long-term care use, because as Isabel has pointed out from her research, use of antipsychotics has gone up during the pandemic in terms of long-term care. We don't know about home and community care, acute care, but in long-term care, it seems like it's gone up. And that's not a good thing because there are health consequences, there are risks associated with these medications. So I want to say 4 things about the law in terms of use of antipsychotics in long-term care. First, if there are special rules that apply. So the law about healthcare consent that I just talked about does apply to antipsychotics in long-term care, but there are extra rules that apply when antipsychotics are administered in long-term care on top of our healthcare consent law. So, and that depends on how the antipsychotics are being used. So the question is always, is the antipsychotic being used to restrain the resident? And if we're talking about, Isabel mentioned aggressive behavior or challenging behaviors, and we're trying to control the resident for their safety or the safety of others, that medication is probably being used as a kind of chemical restraint, like a physical restraint, but a medical alternative to using medication to control people. Sometimes antipsychotics are actually used to improve quality of life for people, even in long-term care, right? Like maybe they have psychiatric issues, there's some kind of suffering, or they're experiencing pain. Maybe the antipsychotic is helping with that. So antipsychotics aren't just always being used for restraint, but when they are, these extra rules apply. So in terms of these extra rules, antipsychotics cannot be applied without consent unless there is an emergency. There are special rules that allow physicians to administer antipsychotics if there are serious risks and there's an emergency. But that emergency, point 3, only lasts for 24 hours. After 24 hours, if you're the family member making healthcare decisions for someone, you should get a call about whether you would agree to continued use of this antipsychotic. And you have to give agreement in writing. The rules for consent to antipsychotics for chemical restraint in long-term care say agreement has to be in writing. Other medication, it doesn't have to be in writing, but for antipsychotics that are restraining, the agreement should be in writing. And then on top of that, there are a whole bunch of extra rules about how restraints should be used in a way to minimize their use. So I won't go into all of them in detail. If you go to our blog post, we have a blog post on our website with all the details, but basics are basically, you can't use restraints to punish folks for behavior. It can't be used just for convenience of staff. And restraints need to be as minimal as possible, and they need to be necessary to prevent harm. They can't be just for convenience. So there are a lot of rules about using restraints so that they're not causing harm to people in long-term care. So that, I promise you, that's the hard stuff of the law that I'm going to be covering my talk today. To wrap up, I just want to remind people that there's a world of difference between folks who can do completely independent decision-making and folks who need a guardian to make decisions for them. And between them, there are some rights I talked about earlier, right? Like maybe somebody can't make decisions by themselves, but they can make decisions if they have assistance with communication. We need to explore that first before we take rights away and go to a guardian. And then further, maybe if they have support with decision-making from someone they trust, they can make decisions by themselves with that support without a guardian. So there are these steps between going to a guardian if someone has difficulty making decisions for themselves. As I mentioned earlier, we've developed some tools to help folks understand healthcare consent law because it can be complicated, and I don't expect you to write everything down I talked about today. So I'll send you to our website. There are links in my slide, and I'm happy to send these slides over to Christine so that she can share them with you. This booklet on your legal rights is a plain language booklet available in English, French, Chinese, and Punjabi. You can find it on our website. And then on top of that, we've developed 3 animated videos to help people understand healthcare consent law, one on who makes decisions for you, one on getting support, and one on what to do to protect your rights if you feel like your rights aren't being respected. You can watch all those on our website. They're each about 3 minutes long. Before I go, I just want to thank our funders. The Vancouver Foundation, the Law Foundation of BC, and the Notary Foundation paid for those tools that we developed with the Alzheimer's Society of BC. And also say, if you have questions, we don't get them today, here's my email on the slide. Feel free to email me. You can also find my email address really easily on our website. The URL is on this slide. We have a newsletter. There's lots of ways to stay in touch. And